right is still right, even if you stand by yourself.
Mr. Chief Justice, may it please the court.
Welcome to Case in Point, the legal show for regular people for this Thursday, March 6, 2025 edition. I am your host, Sarah Parshall Perry, Senior Legal Fellow here at the Heritage Foundation, and we're glad that you've joined us. Lots of legal news at the top of the hour to go over. The Supreme Court on Wednesday backed a federal judge's power to order the Trump administration to pay $2 billion to the U.S. Agency for International Development, or USAID, contractors. But it didn't require immediate payment. In doing so, the court, on a 5-4 vote, rejected an emergency application filed by the Department of Justice after U.S. District Court Amir Ali issued a series of rulings demanding the government unfreeze funds that President Donald Trump put on hold with an executive order. In a scorching dissent written by Justice Samuel Alito, he wrote, "Does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to that should be an emphatic no, but a majority of this court apparently thinks otherwise. I am stunned." End quote. On Tuesday, the Supreme Court heard oral arguments in a case involving guns trafficked from the United States into Mexico. Based on arguments, the court seems likely to block a historic $10 billion lawsuit against U.S. gun manufacturers, as both conservative and liberal justices raised concerns about allowing the government of Mexico to hold firearm manufacturers liable for drug cartel violence south of the border. Federal law grants broad immunity to the gun industry, in part to protect companies from costly litigation that could drive them out of business. But Mexico alleges the law at hand creates an exception for aiding and abetting the illicit sale and trafficking of guns, which the companies deny. A federal district court dismissed Mexico's case in 2022, citing immunity under that federal law. The first U.S. Court of Appeals, First Circuit, reversed that decision in early 2024, saying that Mexico had made a plausible case for gun manufacturer liability under the law's exception. The Supreme Court is expected to decide by the end of June whether or not Mexico's liability case against gun manufacturers in the U.S. can move forward. On today's episode of Case in Point, can a person seek protection from future enforcement of an unconstitutional ordinance if the individual was previously penalized for violating that same ordinance? Now, that's the question that will soon be before the Supreme Court for consideration in an upcoming, soon-to-be-filed petition for review. The city of Brandon, Mississippi, charged Gabriel Olivier for violating a city ordinance regulating where and when he could publicly share his faith with passersby. He pled no contest, paid the fine, and then later challenged the ordinance in court under the First and 14th Amendments. He's now seeking an injunction prohibiting future enforcement of that same city law against his speech. I'll be joined by Nate Kellum, Senior Counsel for First Liberty Institute, to discuss the case, one at the intersection of free speech and legal procedure, on today's episode of Case in Point. Joining me today on Case in Point is Nate Kellum, Senior Counsel for First Liberty Institute. He was also the founder and chief counsel previously of the Center for Religious Freedom, and he is lead counsel in a case that is of particular interest to our listeners and our viewers because it implicates free speech. These are, of course, the cases about which we get the most inquiries and we see the most activity, specifically as related to individuals who are seeking to simply express their sincerely held religious beliefs. But what happens with an individual's desire to speak freely about their beliefs, and when that clashes with a city ordinance preventing him from doing just that? And are there particular procedural elements here that complicate the case? Well, Nate is here to discuss with me the facts, the importance, and the issues at hand in Olivier versus City of Brandon, Mississippi, a case that First Liberty Institute is sending to the Supreme Supreme Court for hopeful review. Nate, thank you so much for joining me on Case in Point.
It's my pleasure, Sarah, and I really look forward to talking about this important case.
So explain a little bit about the facts in this case, because Gabriel Olivier sounds like a fascinating individual, but an individual who simply wanted to do one thing, share his faith in public. Can you explain for our listeners and our viewers exactly what happened?
Well, you describe him well, Sarah. He's a Christian who wants to share his Christian faith, and he does it in public places. And a specific place where he likes to go is a public park located in Brandon, Mississippi. It's right outside the amphitheater. And so during event nights, he can find a steady flow of people in which he can either orally communicate or show a sign or hand out literature, all relating to his Christian beliefs. The city of Brandon did not really appreciate those activities. They wanted to do something about those activities. So they passed an ordinance which would require Mr. Olivier and others like him to go 300 feet away from a major pedestrian walkway, essentially put him in a box where his message could neither be heard nor seen. And that seemed to be the whole idea. Well, Mr. Olivier shows up for a concert, and he quickly surmises that this protest box, that they call it, really would not work. And so he tries to go closer to where he can reach people. However, he was soon arrested, and after arrest, he paid a fine. He pled no contest to it, and he just paid a fine. But what he was really hopeful of doing was to regain his constitutional rights. And so he filed a claim, a 1983 claim in federal court challenging this unconstitutional ordinance. But what happened was the court dismissed it under this legal doctrine known as Heck v. Humphrey.
Okay, so let's talk a little bit about the Section 1983 action. So for our listeners and our viewers, 42 USC Section 1983, for those of us who have been litigators in the civil rights space and worked in this field for a long time, recognize that while it doesn't confer any rights itself, it's a statute that allows individuals to sue state or federal officials for violation of their constitutional rights. And here, Mr. Olivier brought claims under the First Amendment and the 14th Amendment. So specifically, what were the articulations of those claims?
Yeah, primarily free speech. They put forth in the First Amendment to the United States Constitution, we all have a right to freedom of speech. And so that was a major concern here for Mr. Olivier, just his ability to be able to communicate with others, but also his free exercise of religion, because his speech comes from a religious perspective. And so that was infringed upon as well. So as you mentioned, 1983 is a statute that's really a vehicle. And so it's a way that citizens like Mr. Olivier, if they feel like their constitutional rights were violated, and he does, this is a way of being able to present those to the court.
So let's talk about that free speech zone itself, the protest box, as it were. We know the Supreme Court has said that time, place, and manner restrictions on speech are suitable when you are seeking to speak on government property. But when you get to the point where you are 300 feet away from the original source of your ability to communicate a message, it really kind of works as a bit of a heckler's veto, doesn't it?
Well, yes, and that seemed to be by design here by the city, that it wasn't just a matter of allowing pedestrians to have free ingress or egress, to be able to walk to and fro from the amphitheater, because he tends to get 10 or 20 feet away from them anyway. But he wants to be close enough where he can hand out a pamphlet to someone. He wants to be close enough where someone can read a sign. He wants to be close enough where he can carry on a conversation. And yet by putting him 300 feet away, he's prevented from doing any of those things. And so that's why it cuts directly into his ability to speak.
So Mr. Olivier wants to continue to speak. He's already been charged once. He pled the no contest, paid the fine, got to the point where he wants to go back to what he was doing before, but the ordinance itself would prevent him from doing just that. He would submit himself over and over again to criminal liability. So he's trying to seek pre-enforcement relief. In other words, can we determine that this particular ordinance itself is a violation of the First and 14th Amendments? And can we get that determination before I actually have to become convicted and pay another fine. But he was prevented by a case you recently just mentioned previously, the 1994 case, Heck versus Humphrey. So tell me what the lower court here, it was the Fifth Circuit Court of Appeals, determined in why precisely that case was the governing rule and what it prevented for Mr. Olivier going forward.
Well, Sarah, at first glance, it wouldn't appear that this case of Heck v. Humphrey would really have any applicability to Mr. Olivier's situation, because in that case, that involved actually a prisoner, and that really was the principle that was enunciated in Heck v. Humphrey to relate to prisoners. And essentially, what the court held there is that if a prisoner is concerned about a conviction, or they're concerned about the length of their sentence, that they do have an avenue to be able to challenge that, but that's through another vehicle known as a federal habeas corpus, not a 1983 lawsuit. However, here with Mr. Olivier, he was not a prisoner. He never was a prisoner. And also the nature of his relief is he's not trying to relitigate what happened or the fact that he had to pay a fine. He wants to go back. And so and as you mentioned, there's the rub, is anytime he goes back, he runs the risk of just being arrested again. So he's trying to challenge the ordinance to have it declared unconstitutional so he doesn't have to run this risk. And so what happened with the Fifth Circuit, unfortunately, is that they held that Heck v. Humphrey did apply. And so he lost the case there.
So interesting, because if he was never imprisoned, exactly how does he achieve habeas relief? It sort of begs the question of exactly how he gets to recover then if he's barred by a criminal case specifically addressing the relief sought by imprisoned individuals when Mr. Olivier has never been imprisoned. So precisely how does he recover in a situation like this?
Well, that was the upshot of the holding, is that he has no avenue. But because he was arrested, and of course he really didn't have any control over that. He was trying to have a discussion with the police officer about the constitutionality of the ordinance, and he was arrested for that. And then once he was arrested, he was put in criminal court and he paid a fine. But once he did that, according to the Fifth Circuit, then he has no avenue, no way of seeking relief for challenging this unconstitutional ordinance.
Under Supreme Court standing doctrine, we understand that the possibility of an injury must be imminent. Do you all argue in this case on behalf of Mr. Olivier that this is the imminent possibility of injury sufficient to satisfy standing? Because we know here lately the Supreme Court has been very, very strong on its procedural iterations of what's required when a litigant brings a case. And that standing issue has actually really sort of torpedoed a lot of cases that would have been better on down the road, but couldn't get past that initial threshold. So here is the argument for First Liberty Institute on behalf of Mr. Olivier, the fact that this is an imminent injury, very likely to happen.
It definitely is, Sarah. And of course, that raises a huge question here, and one that we believe the Supreme Court ought to consider and rule upon, is that you mentioned like a pre-enforcement type challenge. And if he was never arrested, then I think that would raise a standing issue, because if he's not arrested, how does he know he's going to be affected by the enforcement of this ordinance? However, he was arrested. He knows full well what will happen, because he knew what did happen when he did try to speak in violation of the ordinance. So it would seem like, and Judge Ho, in a dissent in which we filed a petition for rehearing en banc, he said he's the perfect plaintiff, and indeed he is.
So talk to me a little bit about what the Fifth Circuit sort of has followed in relation to the other federal circuits. Are they an outlier in their determination in a case like this that it would only be federal habeas relief, even if an individual had never been imprisoned? Do they stand alone, or is this par for the course when it comes to what the other federal appellate courts have done?
It's interesting. Actually, there is very much a split on how to view this. A very deep one, Sarah. That there's essentially 11 circuits in which these type of claims can be brought, And you have 5 circuits, including the fifth, that has determined that Heck v. Humphrey applies even if you're not a prisoner, even if you have not been a prisoner. And yet there are 5 others that reach the other view, that saying, well, wait a minute, if you didn't have access to habeas corpus relief, then how can this particular doctrine apply to that plaintiff? And then you have a Ninth Circuit opinion that people struggle with trying to figure out exactly what they're saying. So it's really about as evenly split as a grouping of appellate courts could possibly be on that question. But then there's also another question, which we think is really very fundamental in this case, and that is, even if it could apply to someone who is not a prisoner, can it apply to a claim for future relief? Well, because the whole idea, the whole rationale of this doctrine seems to be, well, you don't want the federal court stepping on the toes of the state criminal court and trying to tell the state criminal court how to handle criminal laws. And so you don't want the federal court to relitigate those types of issues. Well, that's not the situation here. He's not trying to relitigate what happened. He wants to go back and he wants future relief.
So you and I obviously know that the deeper a circuit split across the nation from one appellate court to another often increases the likelihood that the Supreme Court will take a case on a petition for review, which is the situation here. In very short order, they will have an opportunity to review the case in chambers and make a determination about whether or not they're going to grant a petition for cert. Is it your hope that with that very deep and complicated circuit split, it might sort of entice the justices further to take the case?
We think so. That because you do have this very deep circuit split about the prisoner aspect of this, but also we think something that could possibly be a hook that could grab someone's attention within that room in which they make these type of decisions, Sarah, is that the fact that it does relate to prospective relief as well. And the Ninth Circuit has had a ruling which is the exact opposite of what the Fifth Circuit has done. So we think in a couple different respects, our case might stick out and could draw enough attention for the court to consider.
Nate, in your view, talk a little bit about the importance of getting access to federal courts and providing judicial relief for individuals who, for example, just want to express their sincerely held religious beliefs in a public forum so that they can share them with listeners. Of course, the old adage of whether a tree falling in the wilderness and no one around to hear it actually makes a sound stands true for the principle of freedom of speech and expression as well. If you want to communicate a message, but there are no viewers or listeners or hearers within that particular arena, the only opportunity for relief really is judicial redress and getting access to the federal courts, isn't it?
It's hard to imagine anything more fundamental than that, Sarah, is really the ability to have your day in court. Just have the merits considered, because the rights are set out in the First Amendment to the United States Constitution, freedom of speech, free exercise of religion. These are rights that are been referred to as inalienable, God-given type rights that we all have. But really, it does very little good to have these rights if they cannot be heard when you believe that there's been a violation, which is exactly the situation here. So judicial redress, the ability to be able to bring those claims in court and have those claims considered is absolutely essential.
What's the message that you would leave our listeners and viewers with about the importance of this case and why it should matter to them?
I think we hit on a lot of it already, Sarah, but really I think it boils down to the fundamental ability to have your constitutional grievance be heard. If you feel like your constitutional rights have been violated, you should have your day in court. And that's what this case is about, and that's why the Supreme Court really needs to take this one up.
Nate Kellum, who is Senior Counsel with First Liberty Institute, thank you so much for joining us. Keep us apprised of the case because we would love to have you back when and if they take it up.
I will do, and hopefully I'll have a positive update.
Thanks again for joining us. Well, that's it for this week's episode of Case in Point, the legal show for regular people. We hope that you learned something, were instructed in some way, were edified, and felt a little closer to the accessibility of why the law matters and the courts matter to regular people like you and I. Follow us on all of our podcast platforms, Rumble, Spotify, Apple, and all the other ones that I can't remember. Leave us a review. Be sure to share the podcast with friends who could use a little law in their lives. Follow us also on X at Case in Point Pod. And until then, friends, court is adjourned.